All right, here we go. 1 o'clock Saturday. You know what that means. Life, love, and the grind. If you're not tuning in, you definitely want to be for this one because I think this is going to be an interesting one. I think we're going to give a take to our viewers that maybe a lot of people don't understand or maybe haven't heard of. So with me as always is Raza. Good to have us back.
Good to be here back in the radio station. I know last week we were at the comfort of my home for the podcast version of the show, but here we are with the formal stuff.
Yeah.
Back at it.
We had to give some people the time off, for the Christmas break, and now we're back. And with us today we have Daniel Epstein.
Great to be here. Thanks for having me, guys.
Well, you are a guest like no other in terms of you are in a position where you are going for Illinois Supreme Court judge. Now, I got to be honest, when I heard about that, I was like, what even is that? I've heard about it. I don't know what it entails, anything like that. So I did some Googling. And if I'm doing some Googling, it means probably a lot of people would have to. Tell me, what does it compose of? I know it's the highest court in the state of Illinois. Tell me what it takes to be a member of there, what it composes of.
Yeah, so you need to be 21 years old, check. You need to be an attorney in good standing, check. And you need to live in the district in which you're running. And the district for me, is the first judicial district. That's Cook County. Everything inside, nothing outside. So those are the legal requirements. And the court is a really interesting and unique body. The Supreme Court is the third of 3 levels of courts that we have in our state system. So the one that you usually see on TV is our trial court. We call it our circuit court. And those are the ones where you're putting on witnesses and you're putting evidence forward and you're determining innocence or guilt. You're determining liability or not liability. And that's kind of what you see on TV most of the time. If there's an error made at that level, or you think there's an error made at that level, then you can basically kind of complain to the manager and you go up to the appellate court. That's the second level of court. And that court exists to review the first court, fix any mistakes that they made. And if you think that the appellate court made a mistake, then you're like, get me your manager. Let's go up a step higher. And that's the Supreme Court. They review the courts below that first and second level of court. And they do that through deciding cases. But here's the really interesting part. The Illinois Supreme Court doesn't just decide cases. That's usually how we think of them, but they also write all the rules for how our justice system operates. They write our rules of procedure, rules of evidence, rules of ethics. They determine things like design standards of courthouses, like the physical design of courthouses, procurement policy, attorney discipline, who gets to be a lawyer and how, data and technological infrastructure, and on and on and on. They are policymakers. We don't usually think about them that way. We usually think of them as case deciders, but they're policymakers. What that means is they have the power to improve our justice system and to prevent injustices that are happening to people in our community, to our families, to us. That's really what my campaign is focused on.
Now, how do you divorce that from the legislative branches? You would think you would think it would be the legislative branch that dictates the laws, or architects, because I'm not thinking judges are the most creative people. And you're telling me the physical layout of these courts are decided by judges at the Illinois Supreme Court. What up with that?
Yeah, it's a confusing situation. So the court does not pass laws. They don't pass statutes, right? What they do is make rules. They call them rules, and they feel and look very similar in many cases, but they're a little bit distinguishable. You can think of them almost like regulations, right? Like our Congress passes laws about aircraft, but then the FAA will pass regulations about how aircraft can navigate and all.
So do they fine tune it? Is that what I'm hearing? That there's a general broad scheme, but this Justice Department, this Illinois Supreme Court defines very specifically what the regulations are? Or am I completely off base?
No, I mean, it's more substantial than that. They really determine a lot of the procedures about how our courts work. So let me kind of illustrate it through example,
please.
Right? So in Illinois, when a judge convicts someone and sentences someone, they don't have to explain how they arrived at the sentence they did. So they'll say, Raza, I find you guilty. I sentence you to 25 years. Next case of Sean. Okay? They don't have to say anything more. And that's a big problem, because if they then say, all right, if they don't explain how they arrived at 25 years, then it's very difficult to complain to the manager and say they made a mistake, because there's no record of what their reasoning was. And people make mistakes all the time in that reasoning. So because they don't have to explain it, we have people who are suffering under erroneous sentences but can't get them fixed. Okay, so the legislature years ago recognized that as a problem, and they passed a law saying, look, judges, if you're sentencing someone to a felony, you have to explain on the record the reasoning behind the sentence that you gave. How'd you arrive at 25 years? You know how every good math teacher always said, show your work? That's basically what they said, right? And the Illinois Supreme Court said, no, 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 no. You don't get to fix this. Breach of separation of powers. This is our power. Only we get to fix this. And then they didn't fix it. So
well,
it's still this
that's
way.
a lot of power.
It's a lot of power.
It's a lot of power.
And it's in sentencing, it's in jury selection, it's in all these different issues. And it's this very kind of strange kind of gray area of where does the legislature stop and where does the court start? In Illinois, it's still quite gray. But there's an enormous amount that the court, that is within the province of the court, that they need to act on, but haven't done so yet.
So let me ask you this. When the court said this is not your jurisdiction to fix this, this is something we have to do, was that a case that was brought up to the Supreme Court? Or did the Supreme Court unilaterally decide that, hey, we're stepping in and taking this? Or did someone bring that case to the Supreme Court that said make a ruling on this legislature versus court policy? How did that go down?
Yeah, so someone who felt that they received an erroneous sentence said, look, there's a law on the books that says you need to explain the sentence, and you didn't explain the sentence, and therefore I should get a new sentencing hearing. And they appealed, and then appealed all the way to the Supreme Court, and the Supreme Court had to then determine.
Just to be clear, Illinois Supreme Court?
Illinois Supreme Court, yeah. And the Illinois Supreme Court then had to determine, is this law requiring judges to make what's called a statement of reasons, is that legit or not? And so then they determined, whether that law was legit, and ultimately they really contorted themselves into a knot to try and say, well, we're going to preserve as much of the law as possible, but basically, no, it's not. You can't force a judge to do this stuff. Only we can.
What do you think of that?
Well, I mean, I think, if we're going to seize responsibility or seize authority over that, I think we need to also accept responsibility. If the court is going to say only we can do it, then they have to then say, is it the right thing to do, and do it. And in this case, I think it really is the right thing to do. If you're sentencing someone to a felony, someone is about to spend decades behind bars and not know what the reasoning was behind it. That's crazy. We need to change that for a number of different reasons. One, because it's inhumane. Two, because it's important that people understand why they're getting the sentences that they are, if we're going to actually have sentences act as deterrents. But then three, and we talked about this a little bit ago, if you make a mistake, there has to be a way for people to fix it. So one of the things that I want to do is say, look, if the court is the only one who can make this change, then let's make the change. Let's do it.
So you have all these people that, and I'm not going to say all these people, right? But there's situations where, like you're saying, these people are behind bars for 25, 30 years. And, maybe they did make a mistake and there's no way to overturn it. How do you help these people that, are lost in the system? And then how do you get them when they come out of the system to actually, is that where there's a big issue with the court system, where people just do feel like it's just so unfair and so biased? How do you fix someone who's wrongfully accused or someone who's doing 30 years to come out now and be like, well, don't take it out on the court system though, it's all fair. How do you help these people that are lost out there?
Right. So I think there's a number of different ways. But first, I think you nailed it on the head, which is, how are you even supposed to know if it's fair if someone doesn't explain to you why you got the sentence you did, right? It's really important that we talk about it, right? That we say, you would have gotten less time if you did this. You would have gotten more time if you did this. There's this idea of deterrence, and there's two different kinds of deterrence: general and specific deterrence. Specific deterrence is, we're putting you behind bars to deter you from doing crime again, right? We're punishing you so that you learn your lesson. Then there's general deterrence, which is, we're punishing you so that everyone else learns the lesson. And both of those require an explanation of what you did wrong. We need the lesson. It's not just enough to put you behind bars and assume that people are going to understand it. Yeah. You have to explain it.
Do either of those counteract recidivism? Do either of those address the problem that when you come out at some point, you're going to need a course of action to maybe avoid some of the situations that put you there?
Yeah, so there's a lot of research on kind of what helps reduce recidivism, and increasingly, I think there's increasing doubt that long sentences are very effective at reducing recidivism. There's really good preliminary research on restorative justice practices in reducing recidivism. So restorative justice practices are practices that kind of take victims off the sideline. In a criminal case, the parties don't include the victims, right? It's the state versus the alleged perpetrator. And the victims are kind of sitting back and act as witnesses or something like that. But they've been kind of sidelined in a way. Restorative justice asks victims to opt into a process that says, look, we're going to get the alleged perpetrator. We're going to get you, the victim. We're going to get members of the community who are impacted by the alleged offense. And we're also going to get what's called a circle keeper, basically a manager of the process. And we're going to get everyone together in one room, and we're going to talk about what happened. We're going to get the alleged offender to own up to what they did. We're going to get the victim to talk about how it impacted them, how it hurt them. We're going to get the members of the community to talk about how it impacted them. And then we're going to come up with a plan to restore first and foremost the victim. Second, the members of the community who are impacted by it. But then also to restore the alleged offender so that when they go through this process and check off everything that they've been asked to do, that they're ready to go back and be a productive member of society. This is something that's been really successful. And we're leaders in this in Cook County. We have the Restorative Justice Community Court in North Lawndale. And I've been proud to support that through supporting the Lawndale Christian Legal Center, which has been part of it. Here's the problem. Those communications within the groups are not privileged, which means that when people say something in that space, that can be used against them in court. Okay, that's a problem because those communications, the process relies on open and forthcoming communication. And if something you say can be used against you later, you're not going to be very open and forthcoming. And if someone then has that happen, right, they say something and then it's used against them, all of a sudden attorneys are going to start saying, don't opt into this process. Or if you do opt in, be careful about what you say, which is against the spirit of the rule of the process. So a group of organizations actually came together to propose a rule to the Illinois Supreme Court saying, hey, make these communications privileged so that people don't have to be afraid to speak openly in this space. And the Illinois Supreme Court rejected it.
So Daniel, you haven't been here
like
before.
a serious issue.
Well, it does seem like a serious issue. I feel like we should delve on this, but you haven't been on this show. You're from Cook County, so you don't know how things work. As soon as this goes too much on the rail, I like to take it right off. When it becomes too much NPR, I like to bring in a little bit of TMZ. So to anyone, you know what? Anyone watching on the live stream, Sarah, if you could pop up the Illinois Supreme Court map, and there's a reason for this. Okay, so you are running in District 1, which if you're looking on Facebook Live, and I'll explain to the listeners, is Cook County. And all of Cook County, it looks like that little green area. Now you have 3 judges on the Illinois Supreme Court who sit from Cook County. Every other district gets 1 judge. Here's my question, right?
So well, then tell them that there's 7.
So there's 7.
There's 7 in Illinois.
7 justices in Illinois, and split into 5 judicial districts.
Yeah,
and this is something I had to look up. And I got to ask because you guys are supposed to be, as judges, beyond like geographical partisan things. You're supposed to make decisions. Why wouldn't this be at-large positions where the entire citizenry of Illinois is depending? Would there be room for, I guess, criticism from people downstate saying, hey, how come Cook County is getting 3 judges making this? Does it turn into a partisan issue? I looked, it's, 7, maybe 8 Democrats running for these positions on the Supreme Court, whereas downstate, District 5, there was more a Republican-Democrat basis. Are these questions that come up? And here's the other thing. I know you're running with against 7 or 8 other people.
Yeah.
What's that like? Because I know politics isn't often pretty. I know it can, delve into unspeakable realms. I would think judges would be past that, but are they? Yeah. Let's pop it back up and look at Dan and Sean's reaction to that question.
Do you remember that whole question?
Yeah. So the first part of it.
It's about a 9-part question.
Right, the first part of it is
and I want it answered backwards.
Yeah, right. So I'll turn my seat around. So yeah, I mean, I think there's some room to criticize kind of the way that it's set up, but broadly speaking, it is designed to be somewhat representative of population, right? So you might actually worry that if it was at large, that all the judges would end up being from Cook County, and so it's a more or less representative of population. It's not perfect. But that's, I think, kind of the idea under it. But in Cook County, so there's 7 justices on the court, and 3 ran as Republicans and 4 identify as Democrats. And or ran as Democrats and are now identifying as Democrats. And in Cook County, the seat that I'm running for, all 8 of the candidates in my race are Democrats. Right? I'm running. My election is March 17th, and that's the Democratic primary. I don't think any Republicans are even running at this point. In the past, when Republicans have run, they just get smashed in the general because Cook County is so blue.
So let me ask you this: whoever wins that primary, do they win the election general?
Yeah.
Okay.
Yeah. It's very, very difficult for Republicans to win in Cook County. It's a Democratic stronghold, and I'm a Democrat. And
it's always been.
For
a very long time.
Very, very long time. That's right. And so, but yeah, so to the extent it is strange to have kind of first of all, it's a little bit strange to have elected judges at all. Although there are a lot of places that do it. But it is a little bit awkward at times. But also having a partisan election for judges is very strange because ultimately sometimes these judges have to weigh in on political issues, right? So there is some discomfort there, and it's a tough line to walk, and sometimes that raises potential conflicts of interest, and there's a question about how we deal with that. So it is a tough issue. Now, the second part that you talked about was, are judges above the kind of dirty politics that we've become accustomed to?
I know they're probably not. Tell me the stories.
We want the dirt here on Life, Love, and the Grind.
Yeah, for the most part, members of our judiciary have been really kind, have upheld what we expect in terms of decorum. And all praise to them. There have been some exceptions, but nothing too crazy. The big things that I'll get calls every now and again saying, you're going to ruin your life. You'll never work in this town again. You'll ruin your reputation, that kind of stuff. It's not the worst thing in terms of Cook County politics that I've ever heard, but it's there, and. But nothing we can't handle.
Well, politics is definitely a dangerous business, and it definitely puts a target on your back when you put yourself out there to run for anything. So where did you kind of come to wanting to get such a high position? What was your kind of road to get to where we are?
Yeah. So it was through cases, frankly, through representing people who were being harmed in preventable ways. And the Illinois Supreme Court is the only entity that can rewrite some of these rules. That I saw harming people. So, the circuit court can't do it. The appellate court can't do it. Those first 2 levels don't get to write rules. The legislature, they can't do it, right? We just talked about what they can't do. The governor can't do this stuff. There are only 7 people in the state who can rewrite many of the rules that I saw hurting people. And so what I wanted to do was just, prevent the harm that I saw happening to people. And there was a case that actually really did it for me. I'm an attorney. I was serving clients in the Supreme Court of the United States and in courts across the country, and came back home to represent a guy who was accused of attempt murder here over in Cook County, and there was DNA at issue in the case, and my job was to learn everything I could about DNA and to mount his defense on that issue, and so I just started reading. I hired a forensic scientist to help me understand what was going on with the DNA analysis. And we interviewed the state's DNA analyst in the case. And what we discovered was pretty scary, which was that the state was using a faulty DNA machine.
Oh,
yeah.
Seems like it affected a couple of people, not just 1 or 2.
Yeah. That's the concern, right? And so, DNA done well is the best evidence we got. It finds people who we would have never found who committed crimes. It's exonerated people who were convicted of things they didn't do. It's proved that people will plead guilty to things they didn't do, which people didn't believe before DNA evidence. But that evidence that is so good when done well requires the use of a machine that's calibrated by a human, and humans are fallible. In this case, the human that was supposed to calibrate the machine failed to do so properly, and so it's producing false results. But I thought, there's a process for that. We'll put that DNA analyst on the witness stand. We'll cross-examine him. We'll bring this issue to light. And once we do that, they'll have to retrain that analyst. They'll have to fix the machine. No one else will be hurt by this. Right? I do a little bit more research. And I found out that in Illinois, our forensic labs are entitled to extra funds if they produce an analysis in a case, if it ends in conviction. Right?
Sounds like they might have something at stake.
Well, it gets worse. Our courts are entitled to extra funds if they convict. Right? Big problem. Big problem. So financial
Hello,
rewards,
Chicago.
all of Illinois,
Yeah,
all of Illinois, yeah.
It's crazy.
DuPage included. So, you know, financial rewards not for finding truth, but for finding guilt. Big problem. But I thought, you know, we're going to go to trial and I'll expose that too. And they'll, you know, we'll make it better one case at a time. That's why I became a lawyer. That's how it's supposed to work. That's not how it worked. What actually happened was we went back into judges' chambers under something called Illinois Supreme Court Rule 402, which is one of those rules that I was telling you about. And it's like a preview of the trial. You go back and the state says, Judge, this is what we're going to show at trial. You say, Judge, this is what we're going to show at trial. And the judge thinks about it and says, all right, well, based on what you told me, if I were to convict, I think an appropriate sentence would be 70-something years. And then you walk out into the hall and the prosecutor pulls you to the side and said, all right, you heard the man 70-something years. But if you plead guilty, I'll ask for 20-something. So then our guy has to decide, do I assert my constitutional right to a trial and defend myself and risk dying in prison, or do I take the plea? And he takes the plea.
And how many of them do take the plea?
So great question. That's what I asked myself.
Yeah.
In Illinois, in 2017, 97.5% of all felony convictions ended in guilty pleas.
Wow.
97.
Based on just what you just said right there. Based on the fear of risking life in prison.
Well, you know, who knows? Maybe some,
or risking maybe 40 years to 20, or
maybe some of them are doing it because they're guilty and they just want to get it over with and they're doing the right thing. But what we know is that the coercive pressure compels some to do it simply because they don't think that they'll actually get a fair trial, right? They're afraid that if they go to trial, that they'll get punished for going to trial and requiring the use of extra resources, and they don't want to risk it. They'd rather just take the plea, even though they didn't do it, or even though they did something different.
And does that go back based on maybe the fear of the court system being biased and being unfair? I mean,
Absolutely.
Is that really what's the overall consensus in a lot of these, especially these certain neighborhoods, certain areas, like they just don't feel like they're ever going to get a fair trial?
Absolutely. Absolutely. I think that's a big part of it. And that is in some cases a valid concern. I mean, there are a lot of the rules that we're trying to change go straight to that issue. Can you get a fair shake in trial? You know, one of the things that we're trying to change is the ability to get a deposition. So in civil cases, when money is on the line, you get all kinds of discovery. You get to do depositions. You get to put sworn testimony on the record before trial, right? But in a criminal case, when a human life is on the line, you don't get to do that. You only get to put evidence on really at trial. But so many of our cases are ending without a trial because they plead guilty. And so none of that information makes the record. So that's what I saw happening in my case, right? And in many cases, you don't even get to really use that tool to prepare your own defense. Depositions are not just good at getting information on the record. It's good in doing an investigation to know how good of a likelihood you have of winning. You know, what did the eyewitnesses actually see? What did the police actually do, right? In a criminal case, oftentimes you don't really get a good sense of that until like just before the trial. Because under something called the Brady rule, the prosecution has to turn over all the evidence that they have that is both material and exculpatory, meaning tending to help the defense and important. But we're relying on prosecutors to turn that information over. Information that is bad for their own case, we're relying on them to turn it over, which is kind of like letting pitchers call their own balls and strikes. Or if you're a pickup basketball person, you know how bad games get when you have to rely on people calling their own fouls. That's kind of how we're doing our criminal system, but we can change that to something called an open file system where we say, look, everything the prosecutor has, the defense should have. This is a better way of doing it. Defense should have depositions just in criminal cases, just like we have in civil cases. We should treat humans and money at least as equals, if not better, for human lives. Because
let's be honest, disenfranchised people are going to get the raw end of the deal 99% of the time. Right. I
mean, so it's up to us to figure out ways to change that. I think that's an accurate description of the status quo.
Yeah.
I think the status quo is unacceptable.
And I think that's a huge thing and why people maybe look down on Cook County in a lot of ways, because they're like, oh, look, everyone's guilty. Look at all these guilty pleas, like they did it. And that right there, I think nails it, of the fear of going to a real trial in a system that maybe they don't feel comfortable in. So they're pleading guilty. And then now all these people are getting thrown into a,
Well, it sounds like it's more of a statewide issue.
Yeah,
too. We always blame Cook County, but it sounds like this might be a systematic problem, or if not a problem, at least something that should be addressed. It sounds more like a problem to me on a statewide level.
Massive problem. Yeah, no, it's all over the state.
Are all the states like this? I mean, not all the states, but is it all kind of pretty much the same?
No, that's one of the really interesting things. Each state is different. There are some commonalities, but there's a lot of differences. So Florida, Indiana, Iowa, North Dakota, they all get depositions in criminal cases. That same thing that I'm advocating for, they already do it. We just don't, right? So we have models that we can look at. Open file, different jurisdictions have moved to open file to make it so that prosecutors have to share evidence with the defense. So the changes that I'm talking about making have already been made in many other jurisdictions, which is how we know that they can work in the first place, and why we don't have to settle for what we have. There are other models that we can look at. Other jurisdictions have ended cash bail. It's a huge problem for working people or for people of lesser means. They've already changed this. We haven't. So we can take a beat from them and say, look, there's a better way to do it. Others have already done it. We can copy it.
Could you explain that to me, the system of cash bills?
Yeah.
I think it's like a 10% in Illinois, is that correct?
Yeah.
But just explain that in terms of how it is with other states in terms of ending it.
Yeah, so bond is the process of figuring out where you're going to spend time between getting arrested and going to trial. A bond court decides that. And they have to basically answer two questions. All right, you've been arrested, you're awaiting the bond court's decision, and they have to determine, one, are you safe to return to the community? If the answer is no, then you're not going anywhere. You're staying in jail pending your trial. If the answer is yes, you're safe to return to the community, there's a second question, which is, how are we going to make sure that you come back for your hearings and your trial, your court dates, right? And historically, the way that's been answered is we're going to require you to put down cash collateral. And by putting that money down, we know that you're going to come back, because if you don't, you'll lose the money, right?
Because you do get that money back, right?
If you come back and you yes, if you come back, then you get the money back. Although if you're ultimately found guilty, they're probably going to take money out of that out of the security to pay fees, fines, and assessments. But yes, you are entitled to get that money back, although it may be less than what you'd hope for. And in fact, so let's say I set like a $900,000 or a $90,000 bond, right? You're going to probably have to put up about 10% of that, which is $9,000. Even if you do everything right and you're found not guilty, you're not going to get $9,000 back. You're going to get $8,100 back, because the county gets to keep 10% of that 10% as an administration fee, basically. It's a pretty expensive administration fee. And there's a question as to whether it creates a bad incentive to kind of create a lofty bail. But here's the problem, right? Which is, it means that when you set a cash bail, let's say $90,000, you have to put up $9,000. What that means is you've been deemed safe to return to the community. You're presumed innocent. But if you don't have $9,000, you're staying in jail, sometimes for years. If you do have $9,000, you're getting out. That is a clear wealth bias, right? That's a big problem. $9,000 is a pretty common one, and a lot of people don't have it. So we're filling our jails with people who can't afford this, not because they're dangerous, just because they don't have money.
And that bond can be a lot bigger.
Oh yeah.
I mean, it could be,
so I mean, there was
20, 30,000, 50,000.
There was a case not that long ago. I can't remember how it turned out, but someone got the administration fee for them was $35,000, right? So they were like, "Hey, county, that's not an administration fee. That's way too big. You need to give this back." And I can't remember how it turned out, but these can be huge. These can be huge. I don't know did you ever watch HBO's The Jinx?
No, I haven't.
So it was that show with Robert Durst, who kept murdering his wives, and rich guy, super rich guy. Yeah. And at some point he gets arrested for murdering a wife, and they're like, "Oh, okay, well, you've been arrested for a really heinous crime, and so we're just going to set a really high bail so that, with the idea being you're not going to get out." And so the bail they set was, for him, he would have had to put up $250,000. He's just like, "Yeah, no problem."
Mm-hmm. Yeah,
right?
because he's loaded. Yeah.
So it's not even really a good way of keeping us safe, because it just means that wealthy people get out, right? Other jurisdictions have changed that. New Jersey's gotten rid of it. DC's gotten rid of it. And here's the great thing: people show up to trial at the exact same rate.
Really?
And that's proven.
Yeah. It's almost no difference at all. The only difference is we have less people in jail, because the thing that gets people to come back or prevents people from coming back isn't money. Usually, by the way, it's not even their own money. It's like their family is putting it together to get them out. It's not the money. It's logistical challenges. It's like an inflexible workplace that makes it so you can't take a day off to go to a court hearing, or lack of transportation, or so. Those are the things that prevent people from coming back to court, we found. So if we really are interested in that, we can just help with the logistical challenges. And oh, by the way, it's going to be way less expensive, because jail is super, super expensive for our taxpayers.
which that's a huge thing, especially in Illinois when everyone's complaining about taxes. I mean, these are little things that can help alleviate our tax dollars.
Oh yeah, incarceration is incredibly expensive. Incredibly expensive.
And that's what I'd like to touch on a little bit too, because I think people don't understand like where they're putting tax dollars. People don't know where they're putting their funds, you know, and incarceration is a huge one.
Yeah.
And I think that's a good thing for people to understand that like everyone thinks it's going all into social programs.
Right.
But majority of it's probably going into
a lot. We
you
are
know,
spending a lot of
probably way
money
too
on
much.
incarceration.
Yeah.
It's very expensive to incarcerate, and you know, in some cases, it is very difficult to justify. Right? If someone is deemed safe to return to the community, and they're presumed innocent, and we know that if we let them out, they're probably going to come back to court. Why are we spending $20,000 to $30,000 per year keeping them in?
Only because they can't come up with money.
Only because they can't keep up with money, and that's not even the full cost, right? Because it's not just the cost to incarcerate; it's the loss of their productivity when they lose their job. It's the collateral consequences for their family when they lose custody or housing or all this other stuff that creates massive costs and disruptions. It's so expensive for us. That's what, when I say the status quo is dangerous, this is what I'm talking about, right?
Mm-hmm.
We are just bleeding money on stuff needlessly. We can do so much better.
So this goes to another one of my questions. So what role does the Illinois Supreme Court justice hold on strengthening working people? And I think this is kind of one of them.
Oh yeah, yeah.
You know, this would help the working person 100% who's deemed safe to society, who got you know, made a mistake like everyone does.
Right. Yeah. No. This is I think one of the best things we could do, and we could do it tomorrow. Right. For people who are not cash rich, we can make it so that we're not keeping people in prison or jail simply because they don't have cash. We can do that tomorrow. There's other stuff too. I mean, you know, sometimes to go down the NPR route, just very briefly. I won't.
Don't worry, Roz will take us back somewhere else.
Go too much on the rail.
The restroom anyways.
So you know, one of the things that can give you a massive, or sorry, so the American system is an adversarial system. The idea is you get two different parties who are going against each other. They go to battle, and the truth pops out. And that's a pretty good system when the two parties are about equally resourced, right? If they're both wealthy or both not that wealthy, then, you know, you can more or less, it's a good system. That's not how it works everywhere. Other places, you have a continental and inquisitorial system where you have a judge who plays a role in asking questions and kind of sitting in the middle and pushing the process forward. Okay. So our adversarial system works well when they're equally resourced. But when they're not, sometimes that battle doesn't result in truth. Sometimes the wealthier party is able to just dominate the less wealthy party through a lot of different ways. You know, better lawyers who can spend more time on the issue, all kinds of stuff. But one of the really key ways is through the use of experts. And expert witnesses are incredibly important in cases. They're like people who show up and give an opinion about their case, part of the case. And they come in with like a PhD from MIT and lots of credibility. And then they talk to the judge or the jury about why their opinion is right. And they are not only super credible and super important, they are super expensive. And what that means is if you're that party with lesser means, you probably can't afford an expert. And if you do, they are probably, you know, they're not an MIT PhD. They're, you know, they're less credentialed, less persuasive. And so you can just get dominated through the use of experts. By the way, in some cases, the wealthy party might even just start hiring experts so that there's no one else that you can hire. If there's a really big disparity, right?
And when you say party, you mean the political party?
No, litigants. So
okay,
like plaintiff versus defendant.
Okay,
yeah. Sorry about that. Plaintiff versus defendant or
prosecutor
versus defendant. Yeah, right.
Yeah.
So
it is, in a way, it's a rigged system leaning towards wealth, which I think is not a huge surprise to me.
I think it could be the way you're describing it. I think that it at least should be considered. And here's one thing. I know you said some things only the Illinois Supreme Court can actually change, which leads me to the question of how does that happen? I know that there's elections that are partisan elections, but I also know there's retention elections. Could you explain to me that? Yeah. And how come out of a system of 5 districts, only 2 are up for election? Is that just every couple of years certain people are up? And what is a retention versus a regular primary election? Yeah, and
I'll just say one last thing on the previous thing, which is that we can fix this. At the federal level and in Europe, they allow court judges to appoint independent experts so that rather than relying on the parties to have to hire their own, they let the judge appoint an independent one that can help us. That's a rule change that we can make to make it so that working people aren't put at a disadvantage when they're faced with a very wealthy opponent. Okay. Your question was about retention elections.
My question was about the election process in general for Supreme Court judges. For instance, it seems to me like out of 5, only having 2 districts which are having election. Is that just because they're staggered elections?
Yep.
And then also, what is the process of a retention election? If there's an incumbent who's running for retention, can people even run against that person?
Right. No. The short answer is no. They can't run against someone who's running for retention. So we have 7 justices. Each of them serves 10-year terms, and you get elected in an open election once, right? And if you win your open election where people can run against you, then you serve your 10 years. And at the end of the 10 years, you only face a retention election. A retention election, no one gets to run against you. But instead of winning the most votes, you have to get 60% of the vote of people who vote saying, yes, I want to keep them. And if you do, then you get to go for another 10 years.
10 years is a long time.
It is.
Seems like a long
I'm
time.
wondering if they say no, you can't. Then you're still free to run in a primary election. Is that then you'd have to run in an open election? Or
I was wondering the same thing. I have to look into this. I was actually wondering this just the other day, but I know that there was an example not that long ago of a judge who thought that they would not get the 60% of people saying yes, but thought in an open election they would get more than 50%. And or at least the most votes, and they did that. They chose not to. They can choose to opt out of retention, and they chose to opt out of retention and ran in an open election and won.
Huh, that's interesting.
And that caused a big kerfuffle.
So how dangerous could it be to have a 10-year election, a 10-year race where maybe you're 65 and by 75 you're like, I'm burned out, and you're just kind of going through the motions.
It doesn't seem like
that's
the
the highest,
change.
most powerful position in Illinois in a way.
Or reconsideration or opposing perspectives. If you're pretty much, like you were saying, the status quo, right? In 10 years, that's a long time for a status quo to remain in place.
And let me, I just want to pick up on one thing, which is you said, what if you're 65? And that's getting up there, right? Mm. The youngest member of our court is, I think, either 66 or 67. The youngest member of our court, right? I'm the youngest in my race by about 35 years. Our court is very seasoned. They're very mature.
Which isn't a bad thing.
You're very complimentary. This is how a judge says what I can't repeat.
Exactly. The swearing rules. But you know what?
But then face it, then they go into 10-year terms.
Yeah, which is good. I mean, we want experience, right? You appreciate experience. I appreciate seasoned. I don't want to think, you're 65, it's over. I mean, but you really, if you get complacent, that's a long time to kind of just turn off and say, you know what, well, I'm not going to run again anyway. So let me just go through the motions when you have such a powerful position. Yeah,
I think there's something to that. And the reason that we have these long terms, at the federal level, it's a life term. Right, unless you stay for life unless there's bad behavior, and the reason for that is it promotes judicial independence. You don't have to worry about the political wins, right? Because you don't want judges making decisions based on politics. The length of our terms are kind of the same idea, but there's a cost to pay for that, which is it is so insulating that sometimes you lose sight of what's going on the ground in important ways. And what that means is when you do have an open election, it's really important that people get involved and express their values through elected judges who are policymakers. That's what this election is about. This is not all praise for experience. Experience is important, but this is not about a promotion. This cannot be about who deserves a promotion. It has to be about an expression of values, because if we have the same justice system in 2030 that we have in 2020, that is a big problem. Big problem. And so we have to express our values. If we're really interested in making this justice system work for the customers of the court, for working people, for the 99.9% of the people who go before the court, we need serious change.
What we were talking before about even just emerging technologies. I mean, some of the e-discovery you talked to might be something that some of the older generation may not even have as much experience as probably is necessary to foster that type of justice.
Yeah, we have to be evolving.
Right.
At the times too.
Correct. Tell us a little about e-discovery and some of the challenges that I believe you probably have to be a specialist to understand the true value of some of this exculpatory. Is that right?
Exculpatory evidence is evidence tending to help the defendant. Yeah. So e-discovery is the process of discovery of learning and discovering information in a case that is electronic in nature, digital in nature. Right. So it used to be the case that when litigants were trying to understand their case, they would ask the other side to turn over information that they had, and it would be boxes and boxes of paper, or it would be witness statements or these kinds of things. That's changed a lot. It is now I was about to say CDs upon CDs, but it's not even CDs anymore. Now it's just giant servers that you fill up with information, and so much data now, metadata, all kinds of really complicated electronic issues, that it has totally changed the way that we do law. And there's a big focus on jury trial experience for judges. Jury trials are a very, very small percentage of what happens in our legal system. Discovery and e-discovery is a huge portion of what actual legal practice is. And if you don't understand how e-discovery works, you're missing a really important part. So e-discovery has evolved a huge amount in recent years because it didn't exist before the internet. It didn't exist in the way that it does before server farms and an understanding of how metadata works. That's stuff that I don't know. It's important to have some hands on there and to understand what's going on in that regard. So those kinds of issues can, if you don't understand how it works, can result in massive inefficiencies, and not just inefficiencies, but abuse of the legal system, because it's also super expensive. And so what people sometimes will do is file lawsuits with the idea that it's going to cost their opponent a huge amount of money just to go through just discovery. And so they'll say, look, I'm filing a complaint against you. It's going to cost you millions of dollars just in discovery. Why don't you just settle?
You see that a lot, I think, in the Justice Department. I was walking down Main Street here. I see a guy up in a tree. I'm like, what are you doing up there? Avoiding my ex-wife's process server. I mean, half of the thing, I think, is just half the time about just inconveniencing the other party and then getting them to spend money. So it seems like this isn't just a civil thing, but it can be used criminally as well, which I could.
On how big money muscles the system,
right?
And always has, always will.
Right.
I mean, well, hopefully not always, but so there's 7 Illinois Supreme Court justices. What do they respond to you, if there is any? And you being young, 30 years younger, I mean, do they take kindly to the kind of change that's happening, or is it kind of a good old boys club?
The justices, with the exception of the one that I'm running against, haven't really communicated with me. They reservation and silence is viewed as a virtue in some corners of the judiciary, and I respect that. But I've talked to a lot of members of our judiciary who aren't on the Supreme Court, members of the appellate court, and members of our circuit court, and people who appear before them, and it's really a mix. Some folks are saying, you're skipping the line, right? You've never been a judge before. You're not playing the game. You don't know what you're doing. You don't have enough experience. So I get some of that. There's another group of people who are members of the judiciary who are saying, oh man, you're saying what we've been thinking for a long time. This is important, right? And so there's a little bit of both. And I got to tell you, I mean, I just brush off the not standing in line stuff. I mean, first of all, just from a factual standpoint, more than a third of all justices of the Supreme Court were never judges before they joined the Supreme Court. It's super common.
Oh, wow.
And that's both the Supreme Court of the United States and Illinois. So great liberal justices: Earl Warren, Louis Brandeis, Elena Kagan, who's on the court right now, wasn't a judge before joining the Supreme Court. Super common. In Illinois, Walter Schaefer was one of our greatest justices. He wasn't a judge before. Thomas Kilbride, who's on the court right now. So that's super common, but more importantly, I mean, standing in line is not a good practice. I mean, right. I don't think that's something that we want to promote. We have a problem with standing in line in this state.
I'm looking at Sean because in the labor movement we hear this quite a lot too. I don't know if Sean necessarily wants me to say, but there's that thing that you got to put your time in, you got to learn the culture.
Yeah.
But it seems like sometimes if you want to be a reformer, you got to have that outside perspective outside of the culture and say, hey, why don't we think about it this way? And I'm sure that's a challenge.
Right. It's both. It's both. Right. We do need folks in there who understand the culture and who make sure that there's a way that we avoid really disastrous mistakes, right? There's a place for heritage, but also there's a cost to it. And so we need both. Look, 6 of the justices of the Supreme Court are very similar. They have a very kind of similar profile, many years on the court and all this stuff. But
what is the face of the Illinois Supreme Court justice? What do they look like? I mean, all 7 of them.
Yeah.
And is it diversity? Does it look like the state of Illinois, or?
No, it's not very diverse. So this is an issue in this race too. So there's, let me just kind of name them. Ann Burke is one from Cook County.
Yeah.
Mary Jane Tice. Yeah. P. Scott Neville. He's one of my opponents. He was appointed to the seat, and he's an interim incumbent who then has to face an open election. Bob Thomas is the Supreme Court justice from the 2nd District, which includes DuPage. Thomas Kilbride, Rita Garman, Lloyd Carmeier. Lloyd Carmeier is about to retire.
So there are a couple women.
Women, there are three of the 7 are women. 6 of the 7 are white. P. Scott Neville is African American, and so there's a racial component to this race, in that people are trying to say, look, we need representation on the court, and this is some have called it the African American seat. And so that's an issue, and it's one that I take seriously. I mean, representation is important, visibility is important, and I know that because I represented people of color who went through this system. And, I'm proud that we're running the only affirmatively anti-racist campaign, the only affirmatively anti-sexist, anti-xenophobic, anti-ableist campaign. It's important because it's important for the customers of the court. And we're the only ones out there talking about how to make things better for the customers of the court. And so it's important that people understand that this is an issue. But there's also kind of a salience bias in this election and in all elections. Salience bias is when you're biased by what's in front of your eyes. Right, you're paying too much attention to what's in front of your eyes and missing what's actually important. And in this election, that's kind of, I think there's something to that. And we have to really remind ourselves that what's important are the people who go before the court: defendants, plaintiffs, prosecutors, victims. Those are people who are important. And if we're not talking about ideas to make it better for them, then what are we doing?
So Illinois Supreme Court justice, there's 7 of them. Obviously, after just talking for 40 minutes, this is an extremely ethical position that you need to be on point. I think, it's so much power. What is Daniel Epstein going to bring with your ethical background that's going to make change and do some of these things that really obviously need to be changed, apparently? Yeah,
this is actually one of the most important things that we can do. Right now, our appellate and Supreme Court justices get to determine their own conflicts of interest, right? So there's no independent body. When someone says, so let's say, Sludge Corp comes and pulls up their truck and dumps it on your front lawn and ruins the value of your property. And you go to a judge, you go in court, you lose, you go to the appellate court or the Supreme Court, and you're suing Sludge Corp. And you find out that one of the judges who is going to be deciding your case has their life savings invested in Sludge Corp. All right. So what you can then say is, hey, judge, or hey, court, this judge can't decide this case because they're invested in Sludge Corp. All right. You know who gets to decide whether that judge can decide the case? The judge who's invested in Sludge Corp. So we're relying on people with alleged conflicts of interest to determine whether they have a conflict of interest, which is a conflict of interest, right? We're relying, and that's a big problem in a state where we have elected judges, because what it means is we're relying on the honor system to stop justices from deciding cases for their campaign donors. And this is not a hypothetical problem. This is something that we've actually seen happen in our state. It's something that we can also prevent by just creating an independent body to determine conflicts of interest. People with alleged conflicts shouldn't decide the conflicts. Independent people should. We can make that change. That's something that we need to do tomorrow.
That sounds like some insane power.
Is there any sort of like a watchdog group that we have watchdog groups that watch municipal elections, state elections?
It's the 7 judges. They just watch themselves and say, no, that's okay.
Yeah, and if you don't agree, they still got another 10 years.
Yeah, exactly.
But is there some sort of like a watchdog group that at least puts this information out there? I'm assuming the judicial isn't the sexiest thing for the media to cover, so maybe it doesn't get attention that way. How do you fix a problem like this in terms of exposing potential conflicts of interest? Are there venues right now, or? Yeah, so I mean, not great ones, right? Mm-hmm. That's one of the big problems. So there's something called the Judicial Inquiry Board, where you can kind of complain about an ethical breach by a judge. But it's not much more than that, and they make decisions without explanations. And I mean, I can just tell you. Let me just give you an example of how this is actually played out. So, in 1999, a nationwide group of car owners sued State Farm Insurance. They won $1 billion, a little bit more than $1 billion actually. State Farm appealed up to the appellate court, and then appealed again up to the Supreme Court. And the case lingered there for years. Right. During that time, then Supreme Court Justice Rarick retired
the 5th district. So there was an election to fill that seat between Lloyd Carmeier and Gordon Mogg. That judicial election turned into the most expensive judicial election in American history. $9 million raised and spent. And the allegation was that State Farm funneled millions of dollars in support of Lloyd Carmeier. Carmeier wins, takes the seat, and then within months, the court is tasked with deciding the State Farm case. So the nationwide group of car owners says to the court, hey, Carmeier can't decide this case. They just funded his entire campaign. And the court said, under our rules, it's not up to us. It's up to Carmeier. And Carmeier said, nope, I'm cool. I can be fair. And he cast the deciding vote in favor of State Farm to the tune of $500 million. That turned into a federal RICO case alleging racketeering. State Farm was trying to buy the seat in order to win their case. And days before Carmeier was set to testify, it settled for $250 million. So here's the really interesting thing, and I want to be clear. I'm not saying that Carmeier broke the rules. I'm saying that Carmeier followed the rules, and the rules are broken. So we got to fix those rules. You know who writes the rules? The Illinois Supreme Court.
How are you and the coalition of every other judge, some 35 years older than you, or how many ever, going to work together to fix this if you were to get into that position? How do you build those alliances to effectuate the changes you want? Because as one person, are you going to be able to do that?
Well, first of all, we don't know that I'm just one person, right? We might have 3 of the 7 who support these changes already, and they're just not we're not getting the changes because we need a 4th. So it might just be we need 1 more.
Most people aren't going to speak out if they're not going to, right? If they're not,
the court is very private. They don't make public their votes on rule changes and stuff like that. So we don't know. But the other thing is, and there's good reason to think that there are justices out there who really care about this stuff, care about making sure that that justice is done properly, even at the ground level. But I'll say it like this. Look, well, there's a British poet who said it best. A guy named G.K. Chesterton. He said, the terrible thing about all legal officials, all lawyers, all police, all judges, all detectives, is not that they're wicked. Many of them are good. It's not that they're stupid. Several of them are quite clever. It's simply that they've gotten used to it. They no longer see the prisoner in the dock. They just see the usual man in the usual place. And what that says to me is there's a huge opportunity for change because the people there aren't wicked and they're not unintelligent. They're just very used to it. And if I can come in there and shake it up and say, hey, there's another way to do things. I've worked in jurisdictions where they do it differently and it was great. Let's do it here too. I think I'll be able to persuade them.
Yeah, no, I like that quote because it is true. You really do you fall into your everyday, your routine. And when you're in a 10-year elected position or a 20-year, policeman or anything too long, you do fall in complacency or routine. That's why people freak out about, elected or full-time politicians. They've been doing it for 30 years because they lose sight of their purpose. Like everyone comes in with that.
They build in their own structure. It becomes the oligarchy of what they're used to. Yeah. This is how it's done. These are the institutions that are set up. Right. These are the questions we don't ask. Then you get the outsider coming in and, at least ask the question. And like you said, maybe it opens minds and hearts to look in at another perspective. Yeah,
we see it at every level, right? Bureaucracies ultimately end up serving themselves in a lot of cases. And so it's important to kind of freshen things up and create some, bring in new blood to make sure we're asking the right questions and hopefully I'll be that.
And I'm probably biased by saying this, but I don't think there's anything wrong with bringing the younger people in. Youngish people in. You got to shake it up a little bit. And I think with millennials, they really do have a certain sense of we do want to make change. There is something that we truly believe in and we want to go for it.
Should I bow out of this conversation? I feel like
you're too old.
No, I absolutely agree that sometimes you got to come in there, bring that fresh perspective. And like you said, it's not always easy. Sometimes you got to fight for it. But I think that's what keeps us relevant is that we're grinding. We're trying to effectuate a change through grassroots efforts.
And that's what we do here. Life, love, and the grind.
1 o'clock on Saturdays.
There it is.
There you go.
So you know what? I give you a lot of.
You came down from where you're from. Tell us what you want to say. What's your last message out there to people listening?
Yeah. So we said it before, but look, the status quo is unacceptable. We know that that the Illinois Supreme Court does not just decide cases. They write these rules. They are policymakers. They determine how our justice system operates. And what that means is they have the power to prevent injustices that are happening to people in our communities. We know that right now there are people who have been deemed safe to return to the community, who are presumed innocent, but who linger in jail sometimes for years simply because they don't have enough cash to afford bail. And on this, our court is silent. We know that right now, our courts are vulnerable to conflicts of interest and judicial corruption. And on this, our courts are silent. And we know that our courts are vulnerable to racist jury selection and bias in sentencing. And on this, too, our courts are silent. What I want to say is we don't have the moral right to remain silent on these issues. And I won't. And so I hope on March 17th, people go to the ballot box and say, look, the status quo is unacceptable. We need to shake it up. And there's a guy out there who's been talking about this stuff, about how we can make it better and fairer and work for us. And hopefully they'll say his name is Daniel Epstein.
Well, I like it. You know, to all of our listeners, to everyone who tunes in to Life, Love, and the Grind, there's not one thing that we stand stronger for than working class people. And you know what? If it's good for working class people, I know it's good for me. I know it's good for Raza, and it's good for us. So I appreciate you standing up for the 99% of people, which we need more people to do that.
Yeah.
We live in a society where the wealth rules, big business rules, corporations. We talked about this last night for about 12 hours.
Yeah.
Of just corporations and big money coming in and really silencing the everyday working person.
Yeah.
And it hurts it's hurting the people in the prisons and the jails. It's hurting the taxpayers who are the 99% of the working class. So at the end of the day, if it's hurting us, it's hurting everybody. So what, you lost my eyes again? Or what?
This is how these conversations go on for 12 hours.
Yeah, exactly. But yeah, no, it's great. I mean, this has been really informative.
Well, we
lot of
appreciate
stuff.
you coming with us. You want to talk about our guests for next week? Because we got another good show coming up.
Next week, what do we got? We got Melissa Mortson and
and the president of the faculty of College of DuPage. So another chance to talk about
we're gonna get some
labor, what they're doing in DuPage County. So again, we look forward to having you guys join us, and thank you for joining us. Thank you, Daniel Epstein, for coming and sharing your views on all of this.
Yeah, it's my pleasure. Thanks so much for having
and
me.
don't forget to go out and vote March 17th.
That's right.
Sounds good. Thank you.
Thank you, guys.